Friends, I am going to discuss two editorial articles in the Hindu. One appeared on August 1, 2022, which titled PMLA Verdict and Erosion of Constitutional Buffers. And today, another article regarding to it has appeared, that is PMLA Verdict, a bulldozer effect on the due process. Both are written by practicing advocates in the Supreme Court. The PMLA verdict, the Prevention of Money Laundering Act, in the Vijay Madanlal Chowdhury's case has been discussed. In the first article, which appeared on August 1, which is titled PMLA Verdict and Erosion of Constitutional Buffers, a case related to Nigesh Tarachand Shah versus Union of India has also been discussed. The present thought-provoking process, which relates to the Prevention of Money Laundering Act, relates to the constitutional validity of the provisions in the draconian provisions in the Prevention of Money Laundering Act has been upheld by the Apex Court in the recent judgment on Vijay Madanlal Chowdhury versus Union of India. The Apex Court has held that, rather it chose to held that, the Section 45 of the Prevention of Money Laundering Act would prevail and very much constitutional. When analyzing the Section 45 of the Prevention of Money Laundering Act, it can be seen that there is an earlier judgment related to the Prevention of Money Laundering Act, which had been delivered in the Supreme Court case on Nigesh Tarachand Shah versus of Union of India. In Nigesh Tarachand Shah versus Union of India, the Supreme Court held that the two bifurcations of the bail conditions, that is, the two bifurcations of the bail conditions had been the accused under the Prevention of Money Laundering Act could be divided into two. One is the severe offense for which the 2018 law had given that an accused over 3 years of imprisonment could be granted bail only when the prosecution is satisfied with regard to the bail conditions and there was reasonable ground for believing that the accused would not commit the crime again. Supreme Court had held that it was unconstitutional. The bifurcation of two conditions, that is, one condition related to the 3 years and above imprisonment accused would be granted bail only on reasonable grounds being cited, was held to be unconstitutional. Later on, the government of India reintroduced such provisions, coloring it as a very new law on this aspect by way of Section 45 of the Prevention of Money Laundering Act. Under Section 45 of the Prevention of Money Laundering Act, the accused could be granted bail on the condition that the prosecution is satisfied that he has reasonable grounds for granting bail. A hearing would be conducted before the prosecution and at the bail stage itself, the accused has to prove that he was not guilty. The reasonable grounds included the belief that the accused would not commit the offense again. Here, in this Prevention of Money Laundering Act, there is a predating event, that is predating crime. The predating crime is the base crime, that is the root crime on which the Prevention of Money Laundering Act would be applicable to for the accused. What is Prevention of Money Laundering Act? The Prevention of Money Laundering Act seeks to prevent the money laundering activities by any person who is trying to make the black money with him the white. If he has committed an offense, the scheduled offense means the schedule under the Prevention of Money Laundering Act states certain scheduled acts. IPC one such act, the Copyrights Act is another such act, then Immoral Activities Prevention Act is one such act. So, the accused who has gathered money by committing any of the offenses under the IPC and the said acts, which are scheduled acts, the money, if is representing as untainted money, that is white money, he has laundered or whitewashed this money into white money from the proceeds of the crime and claiming it as very genuine money.